Hello, and welcome to Fair Housing and Housing for Subpopulations. My name is Liz Keegan. I'm the Director of Education and Outreach at the Fair Housing Center of West Michigan, and I'm pleased to bring you this training resource via a generous grant from the Michigan State Housing Development Authority, also commonly known as MSHA. I am part of the Fair Housing Center of West Michigan Education and Outreach team. You can reach us at 616-451-2980, or you can find us at our website, fhcwm.org. We are also on Facebook and LinkedIn, so we encourage you to find us online and follow. So I'll spend a little bit of time providing an overview of fair housing and fair housing laws before we dive into common questions that we get as people are seeking to provide housing for specific populations, or as we're calling them today, subpopulations. There's issues that we want to raise around advertising and communications, along with some best practices. We'll look at application processes and screening, as well as admissions. And we'll be sure to include information on how to report housing discrimination and some resources as well that you'll be able to find on our website. So fair housing laws exist at multiple levels, and they all are designed around the right to choose housing free from unlawful discrimination. So we have the Federal Fair Housing Act, our state Elliott Larson Civil Rights Act, often shortened to ELCRA, a Persons with Disabilities Civil Rights Act here in Michigan, as well as other civil rights laws, all put together to protect fair housing choice. We know that housing is at a premium and we're facing record housing shortages. So housing is very much on a lot of people's minds, and we certainly understand that. And we're also seeing a movement towards having people design new programs or try to put together creative solutions to get more housing online more quickly so that we can tackle this record housing shortage. So we're really thankful to have fair housing be a part of that conversation, as so many communities are looking at increasing housing supply and housing options now more so than ever. We want to make sure that fair housing is included in these conversations, especially on the front end wherever possible. We're very passionate about what we do because where we live matters, and having equal housing choice makes healthier communities, stronger communities, more resilient communities. It allows for housing from cradle to grave, which is an important responsibility that communities have, is to make sure that there's housing options for all. And of course, we have legal obligations to make sure that we have a housing for all across a spectrum of protected characteristics. Fair housing laws are very broad and protect against discrimination in any part of the housing transaction in the world of rental housing as well as sales. So people looking to buy homes or secure mortgages or loans. Even homeowners insurance can be protected by fair housing laws. They also cover zoning and land use, which sometimes can be issues as communities do look to evaluate how land is being used and look for opportunities to identify places for residents to be built. So that's something to keep in mind, that fair housing centers may be helpful if communities are not open to the idea of different types of housing based on protected groups under law. So the laws really do focus on the lists of what we call protected characteristics, because it's illegal to treat someone differently under federal, state, and local law based on these specific characteristics. If someone is talking about housing for a group of people who is not protected, that is not something that fair housing can address. So we'll look at all of the layers of the laws as well as who is protected, kind of making our way through time and progress under civil rights. We start with the Civil Rights Act of 1968. It's commonly known as the Fair Housing Act. And this first prohibited discrimination on the basis of race, color, meaning skin color, religion, and national origin, meaning where someone is from, their ancestry or ethnicity. So those were the first four protected classes that came online as a part of the civil rights movement. In 1974, the law was expanded to add sex as a protected characteristic. And in 1988, we added disability status protections as well as protections for families with children, specifically with children under the age of 18. So our list is growing here. And then you add the layer of state law under our Elliott-Larsen Civil Rights Act. It's very similar to the laws that exist at the federal level, but it does expand protections and it has changed significantly in the last several years. So our list here at the state level is growing. We've had marital status, which is whether someone is married or not, and age protections in place since 1976 here in Michigan. But most recently, we have added sexual orientation and gender identity or expressions as protected classes that came online in 2024. And then last year in 2025, we had source of income in rental housing added as a protected characteristic. Also, recently, for the first time, a definition of race was added to the state law. For the first time, which was inclusive of protective hairstyles, such as locks, braids, and twists. We have a complementary law here that does echo federal disability protections. This is the Persons with Disabilities Civil Rights Act in 1976, also put in place. So earlier than what we saw at the federal level. This is echoing federal protections, but really does put more responsibility on landlords and housing providers in Michigan to make accommodations or modifications as long as they're reasonable changes for persons with disabilities in their housing if it's necessary for them to have full use and full enjoyment of their housing. So we'll talk a little bit more about that. But you can see, especially if you've been in housing for a while, that our list really has grown. So if you're operating housing anywhere across the state of Michigan, this is the list of protected characteristics that you're going to want to be familiar with or get to know if you're new to fair housing. So we really encourage that you utilize this list as a tool, especially if you're considering designing housing programs that are trying to meet an identified community need. Quite often when we're talking about who we're trying to house, we are going to be talking about different aspects of these protected characteristics. And so we really encourage that this be a part of that conversation early on in terms of developing housing to meet the need of the community without the possibility of violating fair housing laws. We are really committed to working together on the front end so that we don't have projects that come online that are taking applications, opening wait lists, that have discriminatory policies in place. We'd really love to prevent any discrimination from occurring on the front end. It's often quite difficult to undo the harm that housing discrimination can cause an individual, and it can certainly take time and money to respond to complaints. And we also don't want to jeopardize programs that are so highly necessary right now, as so many people are looking for housing that meets their needs. So as I mentioned, at the federal level, we have race, skin color, national origin, religion, gender, physical or mental disability, and families with children as protected groups. Note that there are exceptions for 55 and older and 62 and older housing, which is exempt from federal family status protections and state age protections. So those are the only two age restrictions that are allowed. And sometimes we do see communities adopt an age restriction such as 45, for example, and that does not align, is not in good compliance with state law. So age restrictions have to be reviewed very carefully in the state of Michigan. Marital status is whether or not somebody is married, and then we do have our newer sexual orientation, gender identity, or expression protections that now exist across the state, regardless of how anyone is funded. This is now Michigan law that groups cannot discriminate on that basis. And as I mentioned, we have a new definition of race, including hair texture and protective hairstyles. This is often something that we'll see more in education or employment settings, which are also covered by our state ELCRA law, in addition to housing and public accommodations. But it is a protected characteristic, so of course we want to take that into account. And then source of income for rental units where the landlord owns 5 or more units is now our newest state protection. So that new protection that went online in April of 2025 really focuses on income coming from benefit or subsidy programs that are administered by federal, state, local, or nonprofit entities. So it's really focusing on benefits that come from voucher programs, for example, or other types of subsidies that are issued by those entities. Any landlord that has 5 or more units in Michigan, inclusive of property managers, realtors, brokers, corporations, associations, any limited liability corporations or LLC, Any legal entity that offers residential rental units for rent is going to be covered by this law. So small landlords with four or fewer individual units in Michigan would be exempt. The law specifies that any sources of income counting towards the total income for a rental calculation must come from legal sources and be provided on an ongoing basis. We don't have any clarity as of this time yet for how long ongoing is to be interpreted by the new law, but we'll certainly keep an eye out for that if we get any guidance or if any case law gives us some parameters that we can use. Under the new law, also housing agencies that handle vouchers, that issue vouchers like Section 8 or Housing Choice vouchers or Veterans vouchers called BASH, they must approve applications within 30 days once they have all the paperwork that is necessary to help encourage timeliness and use of those subsidy vouchers. There are also local laws across many communities in the state of Michigan that have their own source of income protections, and those may cover local landlords that are exempt under the state law, but they may not be exempt under their local law. So that's an important element to check for, is to get to know your local protections, because these could allow for additional types of income, child support, alimony, and other non-benefit or subsidy program issued income. So one of your homework assignments is to find out if you have any local protections. There may be others besides source of income. There could be veteran status, political affiliation, student status, and others that sometimes are protected at the local level. For example, here, our office is in the Grand Rapids area. So on the right of the screen, I've listed other protections that exist in Grand Rapids, East Grand Rapids itself, Kentwood, and Wyoming, which is inclusive of things like medical condition, genotype, height, and weight. I've also shared some links here for some free libraries of local codes. So you can go to these pages and look for the name of your local government, village, township, etc. You can also contact your local fair housing center and ask for guidance on any local laws that they are aware of. We maintain a list of laws on our website that apply to our service area, which is West Michigan all the way up through the Upper Peninsula. Sometimes we get questions about whether or not housing or dwellings are exempt from fair housing law. And so I want to be very clear that fair housing laws do cover most types of housing and residences, especially here in Michigan. But the Federal Fair Housing Act applies to what we call dwellings, which are defined as any building, structure, or portion thereof, which is occupied as or designed or intended for occupancy as a residence by one or more families. And it even covers any vacant land which is offered for sale or for lease for construction or location of any sort of residential building, structure, etc. So a very broad definition of what is considered a dwelling under law, which triggers coverage of the application of the Fair Housing Act and likely other civil rights laws. Sometimes there are programs that operate as very short-term shelters. Some shelters really do qualify more as a dwelling, but it can be a challenging analysis. So we have recommended these following multiple factors to be taken into consideration in terms of whether shorter term or shelter style housing is considered covered under fair housing laws. So it takes into account, for example, the length of stay, whether the rental rate for the unit will be calculated based on a daily, weekly, monthly, or yearly basis. Whether the terms and length of occupancy will be established through a lease or other written agreement, what amenities will be included inside the unit, including kitchen facilities, how the purpose of the property will be marketed to the public, whether the resident possesses the right to return to the property. That's an important element, whether they have the ability to come and go, and whether they have anywhere else to go for their housing needs is also a factor that should be considered. So some helpful questions to kind of suss out whether fair housing laws apply, but I really do encourage that that assessment be done thoroughly and documented in terms of that coverage. So examples of covered dwellings that fair housing laws do apply to, certainly apartment buildings, condominiums, and cooperatives. These are often managed by non-housing professionals or co-owners, and so they don't have a lot of fair housing experience or knowledge, or may have never heard of fair housing before. So that is often an area where there's not a lot of familiarity with fair housing. We have dorms and student housing that are covered, recovery residences with wraparound services covered, transitional housing covered, group and adult foster care homes, all covered dwellings under fair housing law. This is by no means an exhaustive list, but I also want to highlight it includes nursing homes, assisted living, and rehab facilities, because if you think about it, those allow for longer term stays. Independent living communities and programs, certainly for older adults, are covered. Homeless shelters that are used as a residence or extended stay hotels also used as a residence, kind of meeting that checklist of factors that we looked at. Any homes rented or sold by property managers or realtors, any fee-based programs that provide a place to live as part of the programming are subject to fair housing laws. And that is often an area that does target specific subpopulations. So that's going to be an important element of our training today. And then, as I mentioned, any vacant land planned for housing. So a little bit of an interactive poll question. We'll have a few of these throughout our video here today. So we'll just dive right in. If my agency does not receive HUD funding, is it still subject to fair housing and civil rights laws? Probably gave some of this away a little bit already, but yes, most housing and housing related services are subject to fair housing and civil rights laws. Some statutes like the Fair Housing Act and the Americans with Disabilities Act, or the ADA, apply regardless of whether an entity receives any federal financial assistance. It's important to know if you have federal financial assistance, because that can trigger additional laws or regulations that you must comply with as a condition of receiving those dollars. So having federal financial assistance can trigger coverage of Title VI, Section 504 of the 1973 Rehabilitation Act, which will help meet the needs of persons with disabilities, and the Age Discrimination Act. Another question here, if we offer a special program or services and provide a place for people to live on a temporary or long-term basis, do we have to follow fair housing laws? Yes. If people live in the provided space as their home, their primary residence, they are not living elsewhere, the dwelling is covered by fair housing laws. It's covered regardless of any additional program or service components offered, which is very common in trying to meet the needs of people who are more vulnerable or who need supportive services, who are accessing a lot of federally funded, state-funded programs that are intended to help target people who are unhoused or have unstable housing. These programs or services may include support for things like substance use disorders. They also may offer job training, life skills training, education, peer support, mentoring, and many other important services that are necessary based on the subpopulations. Sure. So when I talk about housing discrimination, I want to be really clear that not only is it based on those protected characteristics that we've looked at, but there's also covered behaviors. And generally what happens is that people are treated differently, or they receive unfair treatment because of a protected characteristic. So those are the elements that we need to build an allegation of housing discrimination. One, that it's a protected person or population, and two, that there's unfair or illegal treatment in a housing transaction, which is prohibited by law. So examples of that would be a refusal to sell or rent after someone has made a bona fide offer based on one of the many protected classes. So if a sale or a rental is denied because of a person's race or skin color, that would be a violation. Other steps that are taken to make the housing unavailable or to deny anyone based on a protected characteristic would be a violation as well. Sometimes we do see changes in terms, conditions, or privileges related to the home, whether it's a sale or a rental. And if those changes are made specifically because of The applicant being a family with children under the age of 18, for example, that would be illegal discrimination. It's also illegal to make, print, or publish any notice or statements that have a discriminatory preference or limit. So that could be as formal as placing an advertisement, a flyer with housing openings or information, wait list announcements, websites. Even verbal communication is covered here under this element of the law. So that's why it's so important, and we appreciate you taking the time to watch this video for this training to get familiar with fair housing. The laws can be very broad and inclusive, especially in the area of communication about housing opportunities and access. It would also be a violation to falsely tell someone a dwelling is not for sale or for rent based on a protected characteristic. Again, steering people toward or away from particular buildings, floors, or neighborhoods based on protected characteristics is a violation. We also see redlining and reverse redlining behaviors. For example, in a lending context, maybe a neighborhood of color is targeted with predatory loan products, or people are steered out of a neighborhood based on the race of the neighborhood, based on schools, things like that. We don't necessarily see blockbusting as it was originally written into the law, where people were using fear tactics to kind of encourage people to sell, often at a loss because neighborhoods were changing or integrating. But we do see some modern iterations of that. So any sort of misinformation or attempts to cause people to fear for their housing investment could be a violation. And also, in certain circumstances, I mentioned with land use and zoning cases, sometimes we see neighborhoods are not welcoming to adult foster care or sober living or specialized housing developed with a subpopulation in mind. And if the basis of the opposition to the development is related to a protected characteristic, that may violate fair housing law. And that's something that many elected officials may not be aware of either. It's illegal to refuse to permit modifications and accommodations for persons with disabilities. Modifications would be things like allowing for the installation of a ramp at a door or grab bars in a bathroom on a reinforced wall. Accommodations are more changes in services, policies, procedures of a housing program or a provider. So asking for permission to have an extra set of keys for a caregiver or a larger unit for a live-in caregiver, permission to have an assistance animal and a no pets policy, asking for an assigned accessible parking space in a parking lot managed by a property management. Those are all common reasonable accommodations that help people with disabilities maintain their housing and have full access and enjoyment of everything that they're paying for with their rent. It would be a violation to not construct multifamily dwellings in accordance with accessibility requirements. The Fair Housing Act has 7 design and construction standards around accessibility, and those apply to multifamily dwellings of 4 units or more that are being developed now. There's a small, I think we're talking about early 1990s when this went into effect, so all new dwellings need to be aware of those basic requirements. And it's illegal to coerce, intimidate, harass, threaten, or interfere with anyone who's asserting their fair housing rights, trying to use these rights under law, or help others who are trying to use their fair housing rights. It's also illegal to retaliate against someone. For example, if they file a fair housing complaint and the landlord is notified and they retaliate against that person with an eviction or non-renewal notice, that is problematic. Further signs of possible housing discrimination that I think is very topical for what we're thinking about today is being asked for medical information. There's some exceptions for licensed programs that offer healthcare services in conjunction with the housing, but we often see housing providers or programs who are not offering any sort of housing healthcare asking for medical information or sometimes screening people out based on medical information that they do not have the legal right to ask for. So that is something that is really important to pay attention to. It would possibly be a violation to require someone to be able to live without help, only renting to adults or single mothers, putting people into certain buildings because of age, gender, or children, charging fees or not allowing an emotional support animal or other assistance animal. And as I mentioned, not allowing someone to put in a wheelchair ramp or grab bars would also be violations. Other red flags that we see are requiring residents to have a job or work a certain number of hours. There are some people, because of a disability, for example, who would not be able to have a job or work the minimum number of hours, so that would have an impact on that protected group. It's a violation to apply a no felonies policy only to Black applicants, but waiving it for white applicants, that would be race-based discrimination. Making rules that only apply to kids or charging extra for kids. Someone being sexually harassed by a landlord or a maintenance person is a violation of fair housing laws and needs to be addressed immediately. Action needs to be taken to protect the individual and prevent that from continuing, and sometimes that does involve contacting the police. Requiring attendance at religious services is possible housing discrimination, as is only allowing married couples to live together. Remember, state of Michigan has marital status as a protected class. So now that we've kind of familiarized ourselves with the protected characteristics, the behaviors that are covered by law, and some thorough examples of what housing discrimination looks like, we will focus on housing for subpopulations now. There are some unique elements that we do want to take into account here. So as some housing providers are allowed to provide housing that is limited to a specific subpopulation, so long as their admission practices don't discriminate because of any protected characteristic under federal non-discrimination laws. For example, we see programs that are limited to homeless veterans, survivors of domestic violence, sexual assault, dating violence, and their children, or chronically homeless persons and families. Those subpopulations have been upheld under federal law as groups that are allowed to target those subpopulations. And as you may notice, they don't conflict with the protected characteristics under federal law. Looking specifically at sex and gender, housing may be limited to a single sex only when such housing consists of a single structure with shared bedrooms or bathing facilities. This is where you can take into account personal privacy and the physical limitations of how the housing is built and how the access to those specific spaces is handled. It might make it appropriate to be limited to one sex if everyone shares the bathrooms, if there's shared sleeping spaces. The idea is that you can go to the kitchen or the restroom in the middle of the night in your pajamas and have that comfort. But that is only applied in those shared living with those shared facilities characteristics. Those must be present in order to have that limitation to a single sex. Housing may be limited to families with children. If the housing has in residence at least one family with a child under the age of 18, the housing may exclude registered sex offenders and persons with a criminal record that includes a violent crime that should be verified based on a conviction, so long as a child resides in that housing. Housing may be limited to a specified subpopulation if, and this is where a lot of our due diligence needs to come in, if the housing is assisted with funds under a federal program that is limited by federal statute or executive order to that specified subpopulation. It's very important to do the due diligence to make sure that there is a standing statute that is still in operation or an executive order that is in effect that allows for and requires that limitation. You don't want to make assumptions or use old information. You want to make sure that you have something third party, third piece of paper, outside source, whatever it may be, to point to as to the reasons for having this subpopulation, for targeting the housing and not making it equally available across the board. So know what that basis is and make sure that all staff or volunteers or board members know the basis for this limitation for this subpopulation. Examples might be housing assisted with funding from the Housing Opportunities for Persons with AIDS or HOPWA dollars related to that program. That housing may be limited to persons with acquired immunodeficiency syndrome or related diseases. That was based on a recognized need, similar to this other project here. This is Youth Homelessness Demonstration Program, or the YHDP program. It must be limited to unaccompanied youth and young adult households where all individuals are under the age of 25 upon entry. That has been set forth as a specific subpopulation that can be identified and served under those specific programs and those program dollars. Housing admission may be targeted to subpopulations who need the specialized supportive services provided in the housing. This is driving a lot of conversation and community interest in terms of the not only is the housing necessary, but the support services are necessary to make sure that people can take advantage of and remain in the housing. They need the wraparound supportive services. It's appropriate to have them set aside as a specialized service. Things like substance abuse, addiction treatment might be wraparound, domestic violence services, or high intensity supportive services might be necessary and specifically helpful for hard to reach homeless persons, all for example. Some housing may offer services for a particular type of disability. This is something that we have seen a lot of interest and effort around, where families are concerned about where members of their families with specific types of disabilities are going to live either now or in the future. This housing cannot exclude those who may benefit if they are otherwise eligible individuals or families with disabilities who may benefit from the services provided. So there may be a very specific diagnosis and type of service that is kind of the origination or the basis for this development of this housing, but it really needs to be looked at in terms of there may be other eligible individuals with disabilities that could also benefit from those same services, which kind of opens that back up a little bit more. And makes it a little more inclusive. And we really encourage erring on the side of inclusion whenever possible in terms of looking at subpopulations. In addition to doing a fair housing risk assessment and working with your local fair housing center, we really err on the side of inclusive population thinking from the onset. Okay, back to some more of our Q&A here. If my housing program is not federally funded and each family gets their own apartment, can I only serve pregnant women and single women with children? No. If you provide housing without any shared living, you cannot discriminate based on gender. While you can operate housing for families with children, you must accept all families with children, regardless of gender, marital status, sexual orientation, or any other protected class. Keeping in mind the new, fairly new additions to our state law here in Michigan, you must be inclusive in this area. Another question, I work for a faith-based housing program. Can we require that couples must be married to live together? No. In the state of Michigan, you cannot discriminate based on marital status. In one situation I can think of, we had a case brought to us by an 89-year-old gentleman who met his fiance in their senior housing that was a faith-based housing program. She was 91 years old. They were engaged to get married, but in accordance with their standard faith practices, it takes time. A two-bedroom unit came available on the property, and they were interested in acquiring it so that they could combine their households and move in together. And they were very anxious to do so. As he said, she's 91, so we don't have a lot of time. They were denied the ability for her to move in. He was allowed to move into the two-bedroom, and she would have had to maintain her one-bedroom unit. And I'm not sure if this was coincident or not, but the property would certainly benefit from having dual rents from this couple. And so we were able to do some education and advocacy. They were able to move in together more quickly. They did go ahead and get married and live together and had some wonderful years together, but they should not have experienced that barrier in the first place here in the state of Michigan. Another question we often get, can I operate a recovery housing program that targets single men and women only? No, you cannot discriminate on the basis of familial status or marital status. We have federal and state law there. Again, there may be some exemptions for gender limitations in shared living situations only with that shared bathroom and bedroom space. If we offer workforce development and job training as part of our housing program, can we require people to have a job or get a job to stay in the program? No, this discriminates against people with disabilities who may be unable to work due to their disability. Okay, getting into more of the broader best practices now that we have looked at some specifics around subpopulations, we want to make sure that we're offering best practices in terms of advertising and communications, applications, screening processes, and admissions. As I mentioned earlier, fair housing laws are very broad when it comes to advertising and communications. The law itself is a little bit challenging to understand here. This second bullet of ours is Section 804 of the law, where it states that it is illegal to make, print, or publish, or cause to be made, printed, or published any notice, statement, or ad that has any preference, limit, or discriminates on the basis of any protected class or the intention to make any such limit, preference, or discriminate because of a protected class. So that really opens up a broad area of liability. So we want to be aware that anyone who is designing communications or ad content, posting information online, whether it's social media or a website, answering the phone, putting out flyers, any sort of communication, electronic, email, text message, voicemail. We have so many different ways that we communicate now. All of that to say, there should not be any sort of preference, limitation, or discrimination because of a protected class communicated in any of those ways from your promotional materials, which is much broader than just flyers now these days, but also any verbal statements are covered under this section of the law. So it's very important to make sure anyone who's representing access to the housing or the programs is aware of fair housing and knows how to comply with fair housing. To that end, we really encourage focusing on describing the property and the program, not the people, not the ideal participant, the perfect tenant. Avoid any reference to any protected characteristic and really focus on the property, the amenities, the program, the services. And make sure to connect with your local Fair Housing Center with questions and review all materials for fair housing implications before publishing, posting, printing, sharing, sending, etc. It's a different world in terms of how we communicate, which sometimes can streamline things and make things more accessible, but that also means we have to do more due diligence. So if you ever have any doubt about language, do your fair housing homework and take it out. Don't publish until you know you've done that review. It's also important to use the Equal Housing Opportunity logo, especially for federally funded programs. That indicates that the program is open to the public and does not discriminate based on protected characteristics. And so you can find that online. In screening, there's some new best practices that have evolved, and so we wanted to kind of take a look at what the criteria is, what kind of records get used, how we can follow our policies, and establishing transparency with applicants as a key element. It works as a best practice for both sides, and really allowing for applicants to challenge negative information, especially in housing that is limited legally to subpopulations. As I mentioned, you want to be as inclusive as possible and make sure accurate information is being assessed, information that is in line with the existing policy. So we'll talk a little bit more about each of those points, but another element is looking at criminal history and background screening. It has to be done with consistency in mind. We don't want to see criminal history used to inconsistently screen or deny lease renewals, used as the basis of an eviction, or any other means to exclude individuals of different protected classes from housing. This all may be illegal under fair housing laws. It's also good to be aware that accommodations may be required. Any part of your rules, policies, services, and procedures could be subject to a reasonable accommodation request from a person with a disability. And that would include your criminal background screening and some of your criteria. A person's disability might now make it unlikely or impossible for them to reoffend. They might also have now gotten treatment for a mental health disability that was the cause of any past criminal activity. And those are, unique circumstances where an exchange of limited information would be appropriate to make sure that treatment and control has been achieved. But be aware that an accommodation can be requested at any time and at any point. It also has to be individually assessed at the time that it's received. So, a little bit more on policies and screening. Any criminal history screening should focus on the nature, severity, and recency of criminal conduct. So, what happened, how long ago, how severe was it? And then making sure that policies are accurately distinguishing between criminal conduct that really is tied to keeping people, whether that's fellow residents, neighbors, and staff, safe, and keeping property safe. So, distinguishing between convictions for homicide, sexual assault, or arson versus gambling, prostitution, etc. It's a good idea to avoid automatic denials or blanket bans on the basis of criminal history. There's been a lot of case law that has been built up to challenge quite successfully felony bans or 99-year look back periods, things that people just could not overcome. It's also best practice not to look at arrests, but to look at conviction records. There's a lot of flawed data coming out of the criminal history record system, and so accuracy is really sometimes just not available. And so it's encouraged to provide for an individualized assessment to take a look at the information that's being pulled and make sure it's accurate and have that individualized assessment exchange of information to focus on whether or not the person can still meet the obligations of tenancy and making sure that you're using accurate information to make any determinations. Other best practices, we encourage that you check for state or local laws. There may be some program requirements, regulations, or restrictions that also limit or dictate how criminal history screening is undertaken. Some local communities, Ann Arbor, Jackson, Detroit, come to mind. They have newer local laws that do address criminal background checks and have some limits as to what a housing provider may do. There's been a state law that's introduced a couple times now, the Fair Chance Act. Sometimes there's access to housing language used for these laws. So that's an important piece of homework, is to make sure that that regulation doesn't exist that applies to you, or that a local law doesn't exist that would apply to you. You would need to make sure you're operating in compliance with those. We do recommend having written policies regardless of the subject, but also specifically for criminal background screening, and making that available. That transparency to all applicants is really key. That helps them understand the policies that they would be held to. It helps them determine whether they want to move forward with applying. And of course, you want to treat comparable criminal histories similarly, regardless of any protected characteristic. Make sure that you are using that policy and interpreting it consistently. It's always a good idea to maintain documentation of all business decisions related to housing and access, but especially so here, you want to document your screening that you completed, the circumstances that were considered, and the decisions were made. And you do want to keep those records for up to 3 years in the state of Michigan, because that is the longest statute of limitations window that we have for a fair housing complaint to be brought forward. Specifically in that instance, it would be in state courts. Some red flags. So these are not best practices, but things that we have identified that have been problematic and have high fair housing risk. So asking on an application whether someone has a physical disability or a mental health disorder. Even if that information is not used on the application, the simple fact that you have that information at a time when a determination of success or denial has not been made creates fair housing risk. Many programs intend to use it at a different time or look at matching with services. So we see questions about past history of drug or alcohol use. If there's no recovery program or health related resource attached to the housing, it's not appropriate to ask about it unless there's recovery program services that will address that past history. It's not appropriate to ask. Asking someone to list their medications on an application is a red flag. Requiring a meeting or interview, especially in person, with staff or board to determine whether someone is a quote unquote good fit for the program, that opens up a lot of subjectivity and risk. Requiring a medical assessment, especially for housing again that offers no care, is a red flag. Assisted living and nursing home properties that are providing medical care can do a limited assessment, but we do not want to see any sort of assessment outside of those circumstances. So what questions can be asked? These are questions that may be asked of all applicants, but if they are asked, they do need to be asked of all applicants consistently and across the board. So questions about sufficient income, meeting income standards to qualify, references from a previous housing provider, whether or not they've been convicted of any recent crimes that would pose a current demonstrable risk, again, focusing on people and property safety. If it is senior housing, for age and verification of age. Those may be asked of all applicants, and if they are, they should be asked consistently across the board. However, with the caveat that in limited circumstances, generally here, housing providers otherwise cannot ask applicants if they have a disability, details about the disability, about their health or medications, if they can live independently, if they need help with daily activities, especially if there's no help available, no program support there, or if they have received treatment for mental illness. So, as we've covered in certain circumstances, housing designated for people with disabilities may be able to ask limited information about disability status on an application. But again, I really want you to have something to point to as the basis for being able to ask those questions. Housing programs that provide supportive services should only obtain more detailed medical or disability related information after first determining whether the person qualifies as a resident. So having that separation, that space in between there is also a fair housing best practice. Post-admission questions, that's kind of leading us into this area. It can be very common, especially in specific programs, for example, for older adults. Housing providers often seek information about religious affiliation in order to be prepared to contact appropriate clergy or other faith representatives regarding any health-related events. This should be only requested after they've been accepted and not as part of the application. Again, simply having the information on the application, whether it's even ever looked at that point in time, just having that information in your files and in your records creates that fair housing risk. Other questions that would be appropriate after acceptance, beyond the religious affiliation, daily needs. It would be appropriate to ask afterwards to connect with available services. Hobbies or interests, making sure they know what's happening with groups that might be a part of the program. But again, keeping that separate from application and collecting that information after acceptance is appropriate. Housing providers must distinguish between information necessary for application and eligibility and information relevant to intake and services. And you must be clear about the intent of any requested information. So as I mentioned early on, verify, and cite the source for any information requested due to the requirement of funds or programs. Make sure that information is included as to why are you asking this question? Well, it's required as an element of receiving this funding. Put that information out there. Put that as the basis so people understand why the information is being requested and collected. Make sure you establish fair screening criteria in accordance with all of your applicable laws and guidance. So, having your list of protected characteristics, any additional requirements that may be conditioned as part of federal or state funding should be included there. Develop, document, and use clearly defined requirements. For example, we look at minimum household income from all legal ongoing sources. Make sure that's updated into any outdated policies that don't take into account these new protections here in the state of Michigan. Use that list of protections to cross-reference your policies, your screening, all of your documentation. Ask yourself, would anyone be treated differently? Who might that be? Are they protected? Are we applying policies or procedures differently to anyone in a protected class? Doing this on the front end can really eliminate fair housing risk. And then make sure you're undertaking regular reviews of criteria and documents. Document that you did that review, document any updates that were made, and maintain those records. You want to be consistent. Help your staff and fellow team members, board members, anyone who's involved in representing the program, the property, the access to the opportunity needs to have this awareness and communicate properly about criteria and that equal treatment. Even applicants and tenants should be aware of applicable criteria. So having that open transparency enables that clear communication and really helps with consistency. Make sure your application supports your criteria and fair housing. So look for unlawful or outdated questions, especially in regard to protected classes. If you are asking questions about a protected characteristic, determine how that information is used, if it's even being used anymore, and if it's objectively necessary. What is the business justification for collecting that information? And can you show how having that information, even with the justification, is not influencing housing access or decision making? It's really key. You want to practice consistency and verifications. Do this in a consistent but fair manner. Call all past landlords or relevant references. It's not a good idea to pick and choose or only listen to one person's opinion. You do want to get permission before running credit or background checks. With disability-related information, it should never be used to disqualify someone from housing, only to qualify them for housing that may be reserved for people with disabilities or for people with a specific type of disability, and kind of using that broader, more inclusive framework that we talked about earlier. In terms of processes, it's a good idea to accept all applications or inquiries for the wait list if that's feasible. Date and timestamp records for first come, first serve model. That helps with maintaining good records and processes in terms of reviewing applications. Make sure credit check, income references, other conditions of tenancy are all handled consistently. Make sure you have any business reasons necessary for the basis of decisions noted. They need to be legitimate business reasons. Make sure you do that review of any fair housing risk. You want to think about your list of protected classes, be as consistent as possible, and document all steps, keeping in mind that your process must be accessible and that accommodations or modifications may arise at any point. It may be during an initial phone call. It could be during the application process right after they get accepted. It could be after they've been a part of the housing or the program for a year or even 5 years. Anyone can become a person with a disability at any point. It's important to recognize those requests and document them and take action. We have great guidebooks that we're in the process of updating that assist with handling these types of requests, but you do need to be timely and take action. I briefly want to touch on reporting housing discrimination. Anyone can report housing discrimination, and we do get allegations from housing professionals, as well as community members, as well as advocates, as well as individuals who have experienced the discrimination themselves. We encourage you to remember, record, and report. Remember what happened when, write down names, addresses, phone numbers of any involved parties, any witnesses, note dates, times, and comments made. Make sure copies are kept of anything, any advertising letters and emails. Make multiple copies of those. Create that record that can help establish what happened. And then report. Call, fax, or email your local fair housing center. Our centers can walk you or your clients through a series of questions to learn more and provide next steps. Also, from the fair housing perspective, the Fair Housing Center of West Michigan does our best to work with housing industry members on the front end to have those preliminary conversations about housing subpopulations. And so we encourage that homework being done up front. Our intake process for allegations of housing discrimination looks like answering thousands of phone calls a year, taking complaints and cases by phone, email, letter, website form. We do accept anonymous complaints and allegations of housing discrimination. We can directly contact potential clients as long as they give us their consent and authorization to do so. We also request authorization to advocate on their behalf. Everything initially goes through our intake coordinator, but we do what we can with the information that we've received. So the more information we have, the better, and the sooner the better. There is a shorter time clock for filing administrative complaints with the federal and state government. That's between 6 months to a year in terms of a statute of limitations. Federal court is 2 years and state court is 3 years. We're really passionate about our approach of education, research, and advocacy. We really focus on preventing discrimination whenever we can, removing barriers that allow it to persist, and when possible, restoring housing choice when discrimination happens. That can be very challenging in today's housing market as things fill up quickly, sell quickly, lease up quickly. Waiting lists are closed. There's so much of a housing shortage that experiencing housing discrimination on top of a difficult housing market can make it just so much harder. We do our work of education through trainings like this under our generous grant from MISHDA. We do community outreach. We also do the investigations whenever possible. And we do walk by our client's side and help them with filing complaints and doing advocacy on their behalf. I encourage you to connect with your local fair housing center. Our fair housing center has the counties shaded in kind of that teal green, but there are other fair housing groups in the state of Michigan. I'm happy to connect you with them if you end up contacting us first. We all work closely together, so we'd be happy to make sure you know who your local fair housing center is because they're going to know local laws and the state of housing in your communities better than we can. We have a lot of information available on our website. We have lots of resources in terms of fact sheets, guides, sample policies, guidebooks. We have a full page of fair housing laws based on our service area, so we encourage you to check that out. But if you're interested in information specific to advertising, setting occupancy standards, senior housing or condo housing, if you're interested in designing construction or disability protections like accommodations and modifications, and making sure your communication is effective for persons with disabilities, we have lots and lots of resources. So I encourage you to visit our website again at FHC, short for Fair Housing Center, WM, West Michigan.org. So thanks for taking the time to view the video. I encourage you to connect with your local fair housing center or connect with me. We really appreciate, again, the opportunity to provide this training. Thanks again to MISHDA, and thanks for watching.